last class we had discussed 5 different essentials of a valid consideration. Today we'll be moving to the next 2 essentials of a valid consideration. The 6th point states that consideration must move at the desire of the promisor. Now, first of all, who is a promisor or who is a promisee? Two parties to a contract, correct? Now, whoever comes forward and makes a offer is called as promisor or offerer. Okay, now if there is a buyer and a seller, two parties to a contract, now either buyer can be a promisor or either seller also can be a promisor. There's no hardcore rule that only the seller has to give an offer. Okay, anybody can come forward with an offer, or that person who comes forward first with an offer is called as the promisor. So consideration must move at the desire of the promisor. So whoever is coming forward at the request of the offer or to enter into the contract is called as the promisor. Let's look at this essential. An act or abstinence which forms consideration for the promise must be done according to the desire of the promisor. Any act performed at the desire or request of the third party cannot form a consideration. Now here, if Mr. A is entering into the contract with B and saying, I want to sell my house at rupees 10 lakh to B. Now A is the promisor. A is coming forward and putting across an offer to Mr. B. So the consideration has to be according to the desire or conditions of Mr. A. If Mr. B agrees to it, he can enter into the contract. If Mr. B disagrees to it, he may not enter into the contract. Did you get it? So it has to move at the desire of the A. Now Mr. C cannot come into the picture of A and B and then decide the consideration. Okay, there's no third party over here. Only at the desire of the promisor, the consideration is decided. So any act performed at the desire or request of the third party cannot form a consideration. Let's look at the case for a better understanding. Here we have a case that is Durga Prasad versus Baldeo. Let's look at the case. Now Durga Prasad is the promisor. He is a builder, constructed shops in a marketplace at a request of a district collector, the promisor. Now remember here there are two parties, okay? Durga Prasad and Baldeo, that is according to the case name. But what happened in the case is, Durga Prasad is a builder. He's a constructor who builds shops or buildings. Got it? Now the district collector of a particular place offered a contract to Durga Prasad stating that in a particular land, you need to build a complex that is full of shops. Okay? You need to build a shops in this particular complex and I'm going to pay you a consideration for the same. So, according to district collector instructions, Durga Prasad built the shops in the complex. So, who came forward first? The district collector came forward and gave the opportunity or gave the offer to Durga Prasad to build the complex shops. Next, shopkeepers, that is, whoever in the complex has occupied the shops, individual shops to make retail trade, those shopkeepers out of their own interest, remember they are third party to a contract. The contract was only between whom? Durga Prasad and the promisor, that is district collector. These shopkeepers are a third party to the contract. Let's see what they did. Out of their own interest, told Durga Prasad that they will pay commission on the sales made. So they told out of their own interest, all the shopkeepers in the complex, based on the sales we make, I am going to pay a percentage of commission on my total sales amount. Okay, so this was an agreement that the shopkeepers made to Durga Prasad. So one of the shopkeeper was called as Baldeo. Okay, so Baldeo was one of the shopkeepers. He did not pay commission to Durga Prasad and so Durga Prasad filed a case against Baldeo. Now, is Baldeo or the shopkeeper part of the original contract? No. He built the shops as per the instructions of the district collector. These shopkeepers are nowhere a part of the contract. So once he filed a case, let's see what the court told. The court gave a judgment which was in favor of Baldeo. As the consideration must move from the promisor, that is the district collector, and not any other third party, shopkeepers are not liable to pay Durga Prasad. Isn't that right? The original contract was Durga Prasad and the district collector. Any consideration if Durga Prasad had to receive, it has to come at the desire of whom? The district collector, not the shopkeepers, and not even Baldeo, who is a part of the shopkeeper, who is one of the shopkeeper in the complex. So the court said that no, Baldeo is not liable to pay you. You didn't build the shop at the instructions of Baldeo. You build the shop or the complex at the instructions of district collector. So if you need to receive a payment, if you need to receive a consideration, it must be at the desire of the promisor, that is the district collector. Got it? Hope you have understood this case. Moving on to the next point. It may move from the promise or any other person, promisee or any other person. First thing what we told, it must move from the promisor, but it may also move from the promisee or any other person. The consideration may move either by the promisee or any other person. Let's look at this case, Chinnaya versus Rammaya. Here we see a mother buy a deed of a gift made over a certain property. So here we see a mother who has made a certain property which is in her name. She has made a gift deed and has written or transferred the entire property to her daughter called as Rammaya. Okay, her daughter name is Rammaya, so she is the promisor. But she added a condition to this contract with a direction that the daughter should pay annuity of rupees 653 to her uncle called as Chinnaya. So who is this Chinnaya? Chinnaya is Rammaya's mother's brother. Mother's brother. Is that clear? So she told, I'm going to transfer this entire property to you in your name, but then the added condition or the instruction to fulfill is that every year, annually, you are going to pay a sum of rupees 653 to your uncle. Only if you are agreeing to this condition or instruction will I pay this or will I transfer this entire property in your name. So on the same day, Rammaya executed the contract. So she agreed basically to the condition that yes, I am ready to pay uncle rupees 653, and she put it into an agreement. That is to pay to Chinnaya as a promisee. Later what happens? Rammaya refuses to pay the annuity. So Rammaya is who? The daughter, correct? Now first she agreed to pay and now she is telling I am not going to pay the money to her uncle, stating what was the reason for not paying the amount? That uncle did not do anything to receive the money. It was only a condition given by her mother. So Chinnaya sued Rammaya for the recovery of annuity. Now here, what was the contract between the mother and the daughter? So mother executed the contract or offered the contract to Rammaya, that is her daughter, rupees 653 to be paid to uncle. Only if you agree to this condition will I transfer you the property in your name. After the legal formalities were completed, then Rammaya refused to pay, stating that in order that our uncle should receive 653 amount or whatever the amount may be, what has he done? Okay, just for the sake of mother's instruction, I cannot pay him. What is the benefit that I am receiving by paying him 653 rupees was question of Rammaya. But Chinnaya still filed a case against Rammaya because she agreed on the legal papers to pay me, but she is not paying the amount. So he filed a case in the court of law. Let's see what the court says. The contract was signed agreeing to the condition. Remember, when she signed the contract, it was stating that even the mother told, only if you are agreeing to pay will I transfer you the property. So Rammaya cannot accept one part of the contract and refuse the other. Rammaya was made liable to pay the annuity of rupees 653 to Chinnaya. So this contract which Rammaya signed is not two contracts. One is accepting of the property given by her mother, and one was she was liable to pay her uncle. No, these are not two different contracts. These are the conditions or norms of one single contract. As we say, a coin has two faces. So this agreement had two faces to it. One was that she is receiving the ancestral property from her mother, and one side she had the obligation to pay her uncle. If she is refusing to pay her uncle the annuity, it is as good as she is giving up the property, or she is not liable to own the property given by her mother. So court says, since you have agreed upon it and made the legal documents, you are liable to pay the annuity of rupees 653. Is that clear? So this is the contract, or this is the next essential. Point 8. This is the last essential for a valid consideration. Discharging pre-existing obligation is no consideration. Pre-existing obligation means already you are bound by the law or bound by your duty to perform certain obligations. Okay, by law it is your duty to do your work. You cannot get paid extra for doing the duty by law. Performing a legal duty is not a consideration for a promise under the law. Example, A promises to pay money to a police officer to investigate into the crime. The agreement was held to be invalid because the officer is already under the duty to do so by the law. Now here what is A doing? He is paying money to the police officer to investigate into the crime. Now, even if A does not pay the money, isn't the police officer by law, by duty, he is obliged to perform his duty to look into the matters of the crime? Yes or no? So, by law, as a legal obligation, police officer, it's his duty to look into the matters of the crime report or into the matters of crime. Somebody does not have to pay him extra to perform the same duty. So, discharging a pre-existing obligation is no consideration. So, the court says such kind of agreements are held invalid because the officer is already under the duty to do so by law. So, these are the 8 different essentials to a valid consideration.